to go ahead, sir. And I have already reviewed, just so y'all know, I did get on CCIS and reviewed the court file, printed out like the amended complaint. Look, of course, I've read all of the pleadings and the motion and the responses and things like that. So that should get, and I did read the case law that was provided to me in advance as well. So if that helps a little bit. But go ahead, Attorney Kazir, whenever you're ready.
Thank you very much, Judge. And I do appreciate it. I know we sent over a bunch of case law, so I appreciate the court taking the time to read it. We're here on Sheriff Ivey's motion to dismiss Mr. Gay's amended complaint, as the court noted. As just an initial matter and just for record purposes, I want to note that while we're sitting remotely in an Okeechobee County courthouse, just for record purposes, this case remains a Brevard County case. I see the court nodding her head there. That may end up being important later on down the road. We have there's a motion to change venue that's still pending. So just to clarify for the record, this is still a Brevard County case.
Okay, yeah, and that may become relevant, like you said, later on down the road. When you're trying to pick a jury and things like that. But I'm going to guess at that point, if it is ever granted, they probably just send it out here to me if that's ever granted. But for today's purposes, I'm just hearing it. I was appointed to hear it because I believe there might be a conflict for a judge in your county or in your circuit to hear it. But it is still a Brevard County case that I'm hearing remotely.
Perfect. Thank you, Judge. So just sort of an overview, because this is a somewhat lengthy amended complaint. It's got 18 counts. Fortunately, they're largely duplicative. Factually, all 18 of them arise from the same act or series of acts. Sheriff Ivey is alleged to have produced a series of videos called Wheel of Fugitive, in which he seeks the public's assistance in gathering information about the whereabouts of people with active warrants. The allegation is that Mr. Gay was one of 10 people on the wheel 4 times when he was not in fact a fugitive because his warrant had already been served and was no longer outstanding. Mr. Gay has sued for what he claims are those 4 false statements about his status as fugitive. Counts 1 through 4, plaintiff has sued the sheriff in his official capacity for defamation, with 1 count stemming from each of the 4 videos. In count 5, he sues the sheriff in his official capacity for the intentional infliction of emotional distress, which I'll refer to as IED throughout, for all 4 of the videos combined. In count 6, he sues the sheriff in his official capacity for the reckless infliction of emotional distress, which I'll refer to as RIED, for all 4 of the videos combined. In counts 7 through 10, he sues the sheriff in his individual capacity for defamation, with 1 count for each of the 4 videos. Count 11 is IIED against the sheriff in his individual capacity. Count 12 is RIED against the sheriff in his individual capacity. Now, Judge, all of the above counts, 1 through 12, are styled in the amended complaint as being, quote, pursuant to section 768.28 Florida statutes. We'll talk more about that in a bit. 768.28 does not create any causes of action. So it's one of the arguments that we'll be discussing. Counts 13 through 16 are 4 counts of defamation against Sheriff Ivey, 1 for each of the videos. Those are styled as being pursuant to the common law, and each of them are against him.
I'm sorry, you cut out for 1 second. Those are pursuant to, I missed you.
They're styled as being pursuant to the common law, Judge.
Okay, gotcha.
Perfect. And they are alleged to be against him in both his official and personal capacity. And I'm assuming that individual capacity is what was meant there. Counts 17 and 18 are IIED and RIED, respectively, against Sheriff Ivey in, again, his official and personal capacity, and are, again, both styled as being pursuant to the common law. So that's sort of an overview of all of the counts. I'll talk about each one of them, or each sort of set of them, as we go through, but I wanted to give the court an outline. As a preview of coming attractions, my intent is to address the argument in a slightly different order than the one I put in my motion for time's sake. First, I want to talk about the duplication between counts 1 through 12 and counts 13 through 18. I think that's probably the quickest argument, so I'll get it out of the way first. Second, we'll probably spend the bulk of our time today on the sheriff's absolute immunity from suit for defamation, whether that's styled as a defamation claim or styled as IIED or as RIED. And finally, I'll talk about the sheriff's official immunity under Florida Statute 768.28, subsection 9A, for all of the counts against him in his individual capacity. So first, let's talk about the duplication issue. Counts 1 through 12 and counts 13 through 18 are the same claims. They allege the same misconduct under the same legal theories against the same entities. The only difference between them is that counts 1 through 12 are purported to be pursuant to 768.28, and counts 13 through 18 are purported to be pursuant to the common law. One or both of those sets of claims have to be dismissed as duplicative. They're the same claims against the same person on the same facts. The ones that are styled as being pursuant to 768.28. It is important to note that 70 or RIED or anything else. It's important to understand what 768.28 does and what it is and what it doesn't do. Judge, I don't know your background. I'm not practiced in front of you, so I don't know how often you deal with suits against government officials here in Okeechobee. So I apologize in advance if we're covering ground that you're already very familiar with.
Well, first of all, I did have a civil assignment before I rotated to this one. I had the civil jury in St. Lucie, but also in preparation for this, I had already read the statute, so that's fine. But whatever to build your record, whatever you feel you need to go back through or you want to highlight, feel free. I won't find it insulting at all. So go ahead.
Thank you, Judge. I appreciate that. So 768.28, as the court's aware, is a limited waiver of sovereign immunity. The rule in common law for hundreds of years was you can't sue the king, you can't sue the government. The king can do no wrong. Florida waived that immunity on a limited basis in 1973 by passing 768.28. In Section 1, the law waives sovereign immunity of the state and its subdivisions for actions sounding in tort if a private person would be liable under the same circumstances. There are other limitations in that statute. We'll talk about a few of them later, but that's the gist of it. It allows private citizens to sue the government in the same way that they would sue another private actor. But importantly, it doesn't create any new causes of action. There's a ton of case law on this point, but I invite the court's attention to the seminal case on this issue, cited in the motion. That's Trianon Park. That's Trianon Park Condo Association versus City of Hialeah. That's 468 Southern 2nd 912. And I'll quote from it briefly. It says, "We first emphasized that Section 768.28, Florida statutes, which waived sovereign immunity, created no new causes of action, but merely eliminated the immunity which prevented recovery for existing common law torts committed by the government. So there are no causes of action in Florida which are, quote, pursuant to 768.28. It does not create a private cause of action in and of itself for anything. It's a waiver of sovereign immunity for existing causes of action. So here we've got two identical sets of claims. The first set is pursuant to 768.28. The second, those 1 through 12 allege defamation, RIED, and IIED pursuant to that statute, but that's not a thing. The second set, counts 13 through 18, allege defamation, IIED, and RIED pursuant to the common law. Those claims are duplicative. They allege the same facts under the same theories of liability with the same elements. So one set or the other must be dismissed. All defamation suits are pursuant to the common law. All IIED and RIED suits are pursuant to common law. If the court chooses to dismiss the first set, the one styled as being pursuant to 768.28, we would also ask that the court order the plaintiff to clarify whether the remaining counts, 13 through 18, are being brought against Sheriff Ivey in his official capacity, which is another way of suing the sheriff's office, or being brought in his individual capacity, which is another way of suing him for his personal acts. Those are different entities. They need to be broken up. They have completely different, there are different defenses that apply to each one of them. They are, for the purposes of 768.28, mutually exclusive. You have to either allege that there was actual malice or that there was no actual malice. So you can't combine them into one count. So we would ask that the court order a clarification on those if the court leaves 13 through 18. If the court dismisses 13 through 18 and leaves 1 through 12, we would just ask that the language pursuant to 768.28 be stricken from counts 1 through 12, since that's inaccurate. So that's it for the argument on that point. I don't know plaintiff's position on it. Plaintiff didn't address that argument in his response. The next argument, and I think the meatiest one that we'll deal with today, is the absolute immunity from suit for defamation. At the end of the day, Judge, I don't believe that the court will ultimately need to address that issue of duplicative counts, because the entire complaint must be dismissed on absolute immunity grounds. Government officials in Florida simply cannot be sued for defamation based on statements within the scope of their official duties, whether those are styled as defamation or styled as IIED or RIED or tortious interference or negligence or anything else. This has been the case in Florida for nearly 100 years. It is very well settled law. In McNair v. Kelly, that's 184 Southern 2nd 428. It's a Florida Supreme Court case from, I want to say 1966, though I didn't write it down. Judge, I'll quote from it briefly. Quote, "It seems to be well settled in this state that words spoken or written by public servants are protected by absolute privilege from liability for defamation. However false or malicious or badly motivated the accusation may be, no action will lie, therefore, in this state." That remains good law. There are dozens of cases describing this absolute immunity from suit. I've cited a number of them in my motion. I'll quote just a few more. One is from Stevens v. Geohegan. That's 702 Southern 2nd 517. It says public officials who make statements within the scope of their duties are absolutely immune from suit for defamation. Weeks v. Town of Palm Beach, 252 Southern 3rd 258 says public officials are absolutely immune from claims for defamation where their alleged defamatory statements are made within the scope of their duties. If a statement is made by a public official within the scope of his duties, it cannot form the basis of a suit for defamation or IIED or RIED. So I want to clarify something quickly for the record, Judge, because plaintiff's counsel has said a few times in pleadings now that the sheriff has either conceded that the alleged statements are defamatory or has not contested that the alleged statements were defamatory. The sheriff's not conceding anything about these alleged statements. We're at the motion to dismiss phase. The law requires us, this stage in the case, to proceed as though plaintiff's factual allegations are true. The sheriff obviously has factual disputes with plaintiff's allegations and disagrees with his characterization of his statements. Would assert that there's important context that there's missing. But this is not the part of the proceeding where we raise those concerns. So I just want to clarify for the record that we're not conceding elements. We're just discussing the sheriff's argument on motion to dismiss, which is that even if plaintiff's factual allegations are true, there's no cause of action in Florida for defamation against a public official predicated on statements that are made in the course of his official duties. The only question the court needs to answer at this point is whether the statements were within the scope of his official duties. That is a question of law to be decided by the court and not a question of fact to be determined by the jury. Florida Supreme Court said that in Resha v. Tucker, 670 Southern 2nd 56. And we know from other cases, including Brown v. McKinnon, that's 964 Southern 2nd 173, that it is, quote, a departure from the essential requirements of law to fail to dismiss a complaint when it is clear on the face of the complaint that the government official is entitled to statutory or common law. So the court needs to decide today whether the statements alleged were made within the scope of the sheriff's official duties. If they were, the entire case must be dismissed with prejudice. The scope of an official duties is to be construed very broadly. Stevens v. Geohegan, which I cited earlier, holds that an official's duties, quote, extend beyond the enumerated required tasks and include discretionary duties that are associated with a given position. The U.S. Supreme Court in Barr v. Mateo held that an act is within the scope of an official's duties if it is, quote, within the outer perimeter of the official's line of duty. Plaintiff provided some last-minute case law last night, which I think summarizes it well. Didn't see it?
I did not. And just so we're clear, Attorney Travis, I did not get a chance to review that, so I'm definitely not going to rule today until I review that case law. So just to be fair, I said that I'd reviewed everything, and that is something that I didn't get to see. So go ahead.
Sure. Thank you, Judge. And I think that the test of the Jupiter Island is a great case for the defense. It talks about the scope of official duties and says that they are to be liberally construed. It says that the duties are not confined to those things required of the public official, but extends to all matters which the public official is authorized to perform. So, in other words, is this the sort of thing the sheriff acting as sheriff is allowed to do? Right? If the statements were made while he's acting as sheriff, and if they're the sort of thing that a sheriff is allowed to do, then the case law tells us that they're within the scope of his duties, and the statements are absolutely privileged. I normally like to save my responses to plaintiff's arguments until after Ms. Travis has had the opportunity to raise them, but one of them there's discussion now. One of the arguments that plaintiff raises in his response to our motion is that it's not apparent on the face of the amended complaint that the sheriff was acting within the scope of his duties when he produced the Wheel of Fugitive videos. I would proffer to the court that each of the videos in question begins with giant letters saying the Brevard County Sheriff's Office presents, and is followed by the word Wheel of Fugitive around the picture of the official seal of the Sheriff's Office. And they feature Sheriff Ivey in his full dress uniform. So to some extent, I am concerned by any assertion by the plaintiff that they were made in Wayne Ivey's personal capacity without any connection to Sheriff Ivey and the Sheriff's Office. But the plaintiff is correct in asserting that the motion to dismiss state were bound by the four corners of the amended complaint. The four corners of the amended complaint itself established that these videos were produced within the discretionary authority of the sheriff acting as the sheriff. First off, Judge, more than half of the counts are alleged to be against Sheriff Ivey in his official capacity. By definition, official capacity suits are made against a person acting within the scope and course of his official duties. That's what official capacity means. The state or its subdivisions are not liable in torts, as a quote from Florida Statute 768.28. The state or its subdivisions are not liable in tort for the acts or omissions of an officer, employee, or agent committed while acting outside the scope and course of his official employment. For counts 1, 2, 3, 4, 5, 6, 13, 14, 15, 16, 17, and 18, all alleged to have been committed in Sheriff Ivey's official capacity. And by definition, those acts were alleged to have been within the scope of his employment as sheriff, the scope of his duties as sheriff. He's entitled to absolute defamation immunity for those statements. Those counts should be dismissed out of hand as a matter of law, because if the statements were made in the scope of his official duties, he has absolute immunity from suit. The remaining counts, 7 through 12, are alleged to have been solely in his individual capacity. But the substance of the allegations in the amended complaint show that they were also allegedly made within the scope of his duties as sheriff. I'm just going to read, Judge, paragraph 9 of the amended complaint in its entirety, because I think it lays this out pretty well. This is a factual allegation that's common to all counts and was incorporated by reference into all of the counts. What it says is, in each video, Ivey encourages citizens to help capture all of the alleged fugitives featured on the show. For example, on January 26, 2021, Ivey stated that he loves how citizens help get criminals off the street so they cannot hurt anyone else, that he has 10 fugitives on the wheel who need to find their way to the Brevard County Jail. And in all episodes, Ivey tells the audience that all 10 persons on the wheel are fugitives with reservations at the Brevard County Jail, and that he needs the public's help to get them to the jail. Judge, serving warrants, capturing fugitives, getting criminals off the street so they can't hurt anyone else, these are duties that stand at the heart of a sheriff's authority. That's what we expect sheriffs to do. In fact, serving warrants is one of the few things that sheriffs are required by statute to do. That's in Florida Statute 30.15. Soliciting the assistance of the public in gathering information on people with active warrants has been a feature of the American sheriff since we've had sheriffs. And Judge, I think this is an absolutely critical point. Florida courts have directly addressed this question before and have specifically held that sheriffs would make public statements about people who are alleged to have active warrants in an attempt to get those warrants resolved are absolutely immune from suit stemming from those statements, even where those statements are alleged to be false or malicious. Case on point for this is Crowder v. Barbati. That's 987 Southern 2nd 166. It's a 4th DCA case from 2008. I submitted a lot of case law, Judge. I appreciate you reading through all of it. I'm sure it was something of a lift on your end. But if you're only going to read one case, I think this is the one, Judge. It's the facts are very similar to those in the case at bar, and it's only about 2 pages. In Crowder, the sheriff of Martin County issued a press release that labeled Mr. Barbati a deadbeat parent for failing to pay court-ordered child support. The press release described the sheriff's annual Grinch roundup, and it specifically said that Mr. Barbati owed over $1 million in unpaid child support and that a warrant was issued for his arrest. Mr. Barbati sued for defamation, alleging that those statements were false and that they were injurious to his reputation. The sheriff moved to dismiss on the grounds of absolute immunity from suit for defamation. Trial court denied his motion, finding that the statements were not made within the scope of his official duties and therefore were not privileged. And the district court reversed that decision and held, quote, the act of issuing a press release concerning the official duties of the sheriff was within the scope of the office of the sheriff. The purpose of the release was to induce delinquent parents to pay their child support, which is a proper government function. Precedent indicates an inclination to give a broad definition to the term scope of office and its synonyms, and we're persuaded that public policy dictates adherence to that philosophy. The lower court order departed from the essential requirements of law by failing to give a broad enough interpretation of scope of duty. The acts of the sheriff in this case were within the scope of a sheriff's authority. A sheriff is required, Judge, to execute warrants. He's allowed to inform the public of outstanding warrants and solicit their assistance in getting those warrants resolved. That's what Sheriff Crowder did in Barbati. It's what Sheriff Ivey is alleged to have done in this case. Any statements that he makes in that effort are within the scope of his duties as sheriff, and they are immune from suit. Now, plaintiff has alleged in his response to our motion that the statements in this case couldn't have been part of Sheriff Ivey's official duties because, quote, there is simply no law that allows a sheriff to arrest someone on a warrant that has already been served, end quote. To paraphrase, and I'm sure Ms. Travis will put her own words on it, but to paraphrase this argument, because it comes up a lot in these cases, Judge, plaintiff's argument that while calling someone a fugitive might be within the sheriff's duties, falsely calling someone a fugitive can't be. Attempting to serve a warrant might be within his duties, but attempting to serve an invalid warrant can't be. That's plaintiff's argument. And on its face, that sounds reasonable. And as a result, this argument is raised by plaintiffs all the time in these cases, and it is shot down by the courts every single time. The case law on this starts in 1966 in McNair that we talked about earlier. The Florida Supreme Court addressed it with, I was very excited to see this, Judge. This is a name I have not heard since law school. The Florida Supreme Court quotes learned hand in McNair for this proposition. But Judge, this is just sort of to illustrate how common this argument is and how frequently the courts have to address it and shoot it back down. The court said this. The court said that the decisions have always imposed as a limitation on the immunity that the official's acts must have been within the scope of his powers. And it can be argued, as the plaintiff did here, that an official's powers, since they exist only for the public good, never cover occasions where the public good is not their aim. And to exercise a power dishonestly is necessarily to overstep its bounds. That's plaintiff's argument in this case. What the court said is, a moment's reflection shows, however, that cannot be the meaning of the limitation without defeating the whole doctrine. What is meant by saying that the officer must be acting within his power cannot be more than that the occasion must be such as would have justified the act if he had been using the power for the purposes on whose account it was vested. In every defamation case, Judge, the plaintiff claims that the statements made by the government official were dishonest and were injurious. Those are necessary elements that you have to prove, right? That's always the case. They're always alleging that these statements were false. But that is not the case. That is not the test here. Just saying that the statements were false and therefore could not have been part of his official duties, that can't possibly be the test, and the courts have held that it isn't. What McNair tells us, along with the dozens of cases that cite McNair, is this. We understand that a citizen has claimed that a public official made statements which are false and injurious and badly motivated. The court needs to ask whether the statements, if they were true, and if they were motivated by public good, would have been within the official's authority. If so, they were within the scope of his duties and they are immune for suit. That's the test that McNair lays out and that dozens of court cases have followed. There's no credible allegation in this case that a sheriff generally is not entitled to put a list of wanted fugitives on the internet. That sort of act would have been prohibited. Because of that, the sheriff is acting in his authority and within the scope of his duties when he does that. That is true even if the statements about any particular fugitive are alleged to be inaccurate. That's what the court found in Barbati, despite the fact that the sheriff was alleged to be lying when he labeled Mr. Barbati a deadbeat dad and said that he owed $1 million in child support and that a warrant had been issued for his arrest. The court still found that he was immune from suit because those statements were in the scope of his official duties. That's what the court found in Knight v. Starr. That's 275 Southern 2nd 37, when the Orange County Sheriff was sued for giving an interview in which he falsely accused Mr. Starr of committing a heinous and highly publicized crime. The sheriff in that case was alleged to have known that the statements were false at the time that he made them and known that there was no evidence linking the plaintiff to the crime. But the ground that because giving people the status of an investigation, a criminal investigation, is part of a sheriff's duties, whether the statements were true or not, malicious or not, badly motivated or not, injurious or not, the sheriff was immune from suit for making those statements. Across the board, Judge, and I cited maybe half a dozen additional cases in my motion holding the same thing. Courts have held that the test to be applied is whether the statements made by the public official, if true and if properly motivated, would have been authorized under that official duties. If that's the case, then they are within the scope of his duties and he is immune from suit. And in our case, of course, they are. Of course, the sheriff is allowed to solicit the public to convince men and women to turn themselves in or to provide information about their whereabouts to the sheriff. Of course, that's within the scope of a sheriff's authority. Plaintiff spends the bulk of his response to our motion to dismiss on this idea that the defamation immunity, the absolute immunity for defamation suits that I've been talking about this whole time, has been superseded by statute. And specifically, the Florida statute 768.28, Florida's limited waiver of sovereign immunity, also did away with the common law absolute immunity from defamation suit. And that's simply not the case, Jeff. Sovereign immunity is a completely different type of immunity. It relies on an entirely different body of case law. It's applicable in completely different circumstances. This is a somewhat basic principle of law, but it bears noting at this point, and I'll come back to it later, I'm sure. But not all immunities are the same immunity. A waiver of one is not a waiver of all of them. In 1973, Florida passed 768.28 and established a limited waiver of sovereign immunity. Plaintiff argued that in doing so, Florida also waived the completely separate absolute immunity from suit for defamation. And that argument, Judge, has been squarely addressed by Florida courts on several occasions and found to be without merit. I'd like to read a section from Quintero v. Diaz. It's a 2020 case that directly addresses this question. I'm on page 1 of the opinion that I sent over to you, Judge. Excuse me, I guess I'm on page 2 of that opinion. I'm under head note 3. The issue presented in this appeal is whether sections...
Which case are you... I'm sorry, counsel, which case are you on now?
Judge, that's Quintero v. Diaz. It's 300 Southern 3rd, 288.
Let me get there, 20. Tab 20 in this book. Just want to get to the same place. Attorney Travis, you got this as well, correct?
I do. I'm pulling it up.
I just need you when you're ready.
All right. Thank you, Judge.
Okay.
The issue presented in this appeal is whether 768.28 9A abrogates the absolute immunity provided by the common law to public officials who make statements within the scope of their duties when those statements are alleged to be false, malicious, or badly motivated. We hold that 768, there's actually a typo in this, Judge. It says 768.29. There is no 768.29. The whole rest of the case is talking about 28. We hold that 768.2898 does not abrogate such absolute immunity. As the court aptly noted, Quintero's argument overlooks the well-settled fact that defense of absolute immunity or privilege is a separate and distinct concept from sovereign immunity. Then it talks about the reasons why and the historical and policy underpinnings of why these are separate and completely different immunities. Jumping down to headnote 4, Quintero argues that Diaz is exempt from immunity to suit under sovereign immunity, where Diaz's statements were false, malicious, or badly motivated. And Diaz counters that as a public official, he is entitled to absolute immunity for statements that were made within the scope of his duties as mayor. And we find nothing in the language of the sovereign immunity statute suggests that the legislature intended to abrogate or limit the absolute immunity which the common law provides to public officials who make statements within the scope of their duties. Common law immunity provides even greater protection for public officials, shielding them from all statements made within the scope of their authority, however false or malicious or badly motivated the statement may be. Judge, I mentioned that it's a common thing. You, Judge, enjoy judicial immunity for your judicial acts. You're a state official. I'm assuming somewhere in that courtroom you've got an 8-foot tall seal of the state of Florida I don't know, maybe you don't. I'm not been in that courtroom, Judge. But despite the fact that you are a state official and 768.28 did not specifically carve out an exception for judicial immunity, you still enjoy judicial immunity. It's a completely separate thing. 768.28 is a limited waiver of sovereign immunity. It does nothing to other forms of immunity. Testimonial immunity that shields individuals testifying in court proceedings, prosecutorial immunity for prosecutors' official decisions, judicial immunity, or absolute immunity for defamation. This was addressed in Quintero v. Diaz. It was addressed in Weeks versus Town of Palm Beach. It has been found to be a meritless argument, Judge. Again, not all immunities are the same. As Ms. Travis presents her arguments, as soon as I finish up, I would ask the court to dig into the cases that she provides and ask whether those cases address absolute immunity for defamation or whether they're just related to other types of immunity like qualified immunity or sovereign immunity, because they're not all the same.
Thank you.
Okay. Sorry, Judge. I want to address another thing briefly, which is that this immunity applies whether they are styled as defamation or whether they are styled as IIED or RIED. Plaintiff didn't address this in his response, so again, I don't know what the plaintiff's.
I'm sorry, counsel, you just broke up for a minute. You said you did, and I'm not sure if that did for the court reporter as well. So if you can repeat that, you said, I heard you when you said you were going to make whether there was this distinction of the immunity applying to defamation or to the other claims regarding the intentional infliction, reckless infliction, but then you got broken up. So if you can please repeat that.
Thank you, Judge. Yes, Judge. I'm not sure what plaintiff's position is on this because it wasn't addressed in his response to our motion. But I will note that there is a case specifically on point for it, which is Friedovich v. Friedovich, Florida Supreme Court case 598 Southern 2nd 65. It essentially holds that where there is a defamation immunity that's asserted, you can't just make an end run around it by saying, oh yeah, and also the defamatory statements were outrageous, sufficient to state a claim for IID or RID. Yes, Judge? Counsel,
I didn't see that in the case law that you provided. I always remind people if you're going to cite case law, please make sure me and the other side have a copy. So if you can, please make sure you get to that ASAP to me and to Attorney Travis. I didn't see it in there if you did.
Absolutely, Judge. And give me just one brief moment to make sure. Well, we'll send over a copy.
Please. Maybe it was sent in the email. I'm looking in the binder.
Okay. I'll check to make sure, Judge. But it is a Florida Supreme Court case. I'm happy to provide the court with the citation, which is 598 Southern 2nd 65, and I'll provide a highlighted copy to the court separately when we finish up here.
And my only concern also, and I'm sure you probably already know this, if you do provide a highlighted copy to me, just make sure that the copy provided
is Travis will have one.
highlighted as well. Yes, thank you.
I don't want
I have a copy. I mean, you can provide another one. Great.
Oh, you did get it. Was it in the emails, Attorney Travis?
I'm not sure. I pulled it during the course of my prep, so I might have pulled it.
Oh, gotcha. Okay. All right. Thank you. Go ahead, counsel.
Perfect. Thank you very much, Judge. I'm not going to spend a bunch of time on it here. I'll address it if Ms. Travis brings it up and go into more detail on it. But the last thing that I want to talk about is the separate type of immunity, official immunity under 768.28. subsection 9A that we did raise. And that's on behalf of Sheriff Ivey in his individual capacity. That's counts 6 through 18 are the ones that are styled as being his individual capacity claims. This is a separate and independent immunity from the absolute immunity for defamation that I've been talking about for the last 48 minutes. Judge, this one derives from statute and not from the common law. The statute says that no officer, employee, or agent of the state or any of its subdivisions can be held liable in tort or named as a party defendant in any action as a result of any act, event, or omission of action in the scope of his or her employment or function unless they acted in bad faith or with malicious purpose or in a matter exhibiting wanton and willful disregard for human rights, safety, or property. As I've discussed above, those acts were allegedly taken within the scope of Sheriff Ivey's employment as the sheriff. He's presumptively entitled to immunity from suit in his individual capacity as a result. So to overcome that immunity, plaintiff has to allege facts which would support a contention that Sheriff Ivey acted in bad faith or with malicious purpose or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. Those terms are defined by case law. The burden they place on the plaintiff is an extremely high one. Not just any intentional tort is sufficient to get over that hump. Under Florida law, it means actual malice. It means a subjective intent to do wrong. It means an act which is committed with ill will, hatred, spite, or an evil intent. It is defined as being worse than gross negligence and more reprehensible and unacceptable than mere intentional conduct. Those are for each of those terms, definitely, because I've broken them in my motion that I don't want to waste the time by going again in more detail. But plaintiff simply hasn't pled any facts sufficient to overcome this burden. To show that Sheriff Ivey acted with a subjective intent to do wrong, with the factual allegations fall Judge, far short of standard. And as such, all of the counts against him in his individual capacity, that's 7 through 18, must be dismissed. Judge, as a final matter, I would ask that these dismissals be with prejudice. The defects in the amended complaint are not defects in the form of the pleadings. Rather, they are substantive defects that can't be cured by amending a second time. Plaintiffs attempting to perform an end run around decades of precedent establishing absolute immunity for government agents who make statements pursuant to their official duties, and no amount of repleading will fix that problem. So we would ask that the dismissal be with prejudice. Thank you, Judge.
Thank you. Attorney Travis.
Thank you. Can you hear me first before I get started?
Yes, ma'am, I can hear you just fine. Thanks.
Okay, great. I want to clarify something from the get-go. My client, David Gay, was at all times cooperative, reporting to probation, gave all of his contact information. And so the complaint alleges that Sheriff Wayne Ivey committed defamation by not saying that he had a warrant that at some point was served prior to the Wheel broadcast, but rather by labeling him a fugitive. And the Black's Law dictionary defines fugitive in a manner that is very commonly understood, I think. And it is cited in my complaint that a fugitive, defined by Black's Law Dictionary and also commonly understood, is, quote, someone who flees or escapes, a refugee, or number two, a criminal suspect or witness in a criminal case who flees, evades, or escapes arrest, prosecution, imprisonment, service of process, giving a testimony by fleeing the jurisdiction and hiding. So this distinction, I think, is important because if we accept the narrative that the sheriff is putting forward, that this is merely about his obligation to serve warrants and therefore he was within the scope of his duties and therefore immune, it really mischaracterizes what the lawsuit is about. This lawsuit is about calling someone who was at all times cooperative, a fugitive, to the extent that when he continued to be cooperative, had his legal case resolved and was released and went to report for his job, he was told not to show up because he was considered a fugitive, and that label also subject him to personal danger of people reporting him, trying to apprehend him, etc. So I think that clarification needs to be made. The facts regarding the warrant go into and support the claim that the calling of the fugitive is the defamatory act, but it is not the service of the warrant exactly that he is alleging is defamatory or saying that he had a warrant. So with that distinction, I like to always propose an analysis to the court. Obviously, the court is experienced and can follow whatever analysis it thinks is appropriate. But to me, the analysis in this case is looking at the four corners of the complaint, looking at what is facially pled. And I think that the first place to start is it clear on the face of the amended complaint that Sheriff Wayne Ivey was acting within the scope of his duties? And from there, you go into the immunity. If it is clear on the face of the complaint, amended complaint, that he was acting within the scope of his duties, the court needs to consider whether or not he was absolutely immune or whether or not the statute waived absolute immunity, and whether or not the statute, for the record, 768.28, the waiver that we're all talking about, or whether or not Wayne Ivey is still subject to individual liability under subsection 9A of the statute because he acted with bad faith, malicious purpose, or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. So the court needs to go into that analysis if it thinks that from the face of the complaint, it is established that he was acting within the scope of his duties. If the court does not think that the amended complaint finds that establishes that Wayne Ivey was acting within the scope of his duties, then the sheriff needs to raise his defenses. I would reply. We might revisit this on a motion for summary judgment, but that I think is the inquiry. And obviously, if that's where we go, I would argue that he is not immune, obviously, if he's not within the scope of his duties. But that is the inquiry, I think, at this moment in time. It's real easy at this point, I think, to lapse into motion for summary judgment type arguments. It's hard to distinguish the two, but I think that needs to be the focus, what is facially on the complaint. And there's been, just as a preliminary matter, some complaint about the way that I titled, and maybe pursuant to the statute wasn't the best phrase. In fact, I don't think putting pursuant to the statute makes the count defective because it alleges the common law elements for defamation. I think I could have left that argument off, or I could have said contrary to, but even if the court struck that, because the statute doesn't create a cause of action, the counts themselves have the elements of the common law cause of action for defamation.
Can I just ask you, can I ask you then, hearing exactly what you're saying, then can you make sure, and you may be getting there, if that is the case, that it is, even though you said pursuant to statute, that you're proceeding under common law, but then the later counts proceed under common law. So then if you can just address the duplication, that would be super helpful.
I'm allowed to plead. I'm allowed to plead in the alternative, and these are kind of alternative counts. And so on some counts are alleging official capacity, and I'm citing, and I put pursuant to the statute, and maybe I should have not put that, but the last paragraph of each count cites why there is no immunity under the statute, and that is to overcome a motion to dismiss type argument or a motion for summary judgment. It's anticipating that. And so there might be, ultimately, if the court finds that, okay, Jessica, you drafted these weren't really pursuant to the statute, even though you have that language, you might find that there is some duplication with the ones at the end of the complaint. But yes, I was covering all bases at this point. And it might be in the long run that you dismiss some counts and not the others. But I don't think it's fatal. I don't think it's fatal to the complaint overall or requires a dismissal with prejudice. I am aware of the case law, and I will get into the case law and address that's been brought up. But I do think at this moment, it's the focus is on the four corners of the complaint. The court can strike some of the counts if they think it's duplicative, or if you think that it survives and generally, but is maybe inartfully drawn, you could dismiss and I'd ask for leave to amend and redo that. I'd like to focus a little bit on the facts of this case because I said that the analysis, I think, begins whether or not the I think the facts of the complaint actually show some intentional knowing.
Just a second. You kind of went skipped a little bit, so I can just repeat that sentence.
Okay. I'd like to focus on the facts because I think the facts go into whether or not the amended complaint shows that Sheriff Wayne Ivey was acting within the scope of his duties, and I don't think it facially establishes one way or the other. I think it shows an intentional knowing and very reckless use of people's identities to potentially pat the wheel, that this was not the service of a warrant that the defense wants us to believe, because, not only was David Gay in custody, he was not a fugitive. He was in custody prior to ever being on the wheel. He was in custody 3 times when he was in the wheel, and he was lawfully released and had all his matters resolved the last time that he was featured on the wheel. And so what the facts of the case, the facts alleged in the amended complaint show is rather a promotional social media show by the sheriff that includes flashy music, spinning wheel, a showmanship type behavior. And it is not, even on the facts alleged in the amended complaint, believable that this was really an attempt to serve warrants, because the wheel regularly featured people in the 12 pages that I have attached to the amended complaint that in fact did not have warrants or had their warrants resolved either through turning themselves into custody or set aside, or who were otherwise not in jail. So I believe it's a little disingenuous to now say that the amended complaint establishes that Sheriff Ivey was doing something within the scope of his duties, when the facts of the amended complaint also show that the duty that they are purporting that it was serving was actually not serving, because other individuals who did not have warrants were featured on there to the extent that there's 12 pages attached to the amended complaint. And I don't know if those other people were fugitives, true fugitives or not, by the dictionary definition, or as we commonly understand. But again, this is a lawsuit about being called a fugitive, when in fact my client was not a fugitive. Calling someone a fugitive who is otherwise cooperative is not in the scope of a sheriff's duties. And it does not serve any sort of purpose, especially in this case, of serving a warrant. There's just absolutely, yes, I agree that the sheriff is allowed to serve warrants, but labeling a cooperative citizen as a fugitive does not serve that purpose. And there was no warrant at the time. And in fact, had Sheriff Ivey attempted to serve Mr. Gay with a warrant, it would have been an illegal search and he would not have been immune from suit. So if a sheriff is not immune from serving an invalid warrant on someone, they cannot be immune from saying that someone has a warrant when they in fact have cause to know that they don't have that warrant. So it does not serve the purpose of serving a warrant to call someone a fugitive in this case, or even to say that the person or indicate that the person has a warrant and therefore is a fugitive. As I indicated, I don't think that even having the wheel show itself is within the scope of the sheriff's duties. And I think it's very questionable just due to the pervasiveness of the number of people who are obviously put on there to essentially pad the wheel because they themselves do not have warrants. It is either extremely reckless or an intentional padding. And it's important to note that the wheel always landed on someone who did actually have an active warrant, which would indicate some knowledge about who did and did not have a warrant. So to suggest that because the sheriff is allowed to serve warrants, the wheel is within the scope of his duties is a little disingenuous, because it actually was more of a promotional show than to be effective because it had other people on there who in fact did not even have warrants. I know that the sheriff argued in their response that the wheel is obviously within the scope of the sheriff's duties because it had a good success rate. And the success rate could have been from manipulation as well. We know that the wheel was likely manipulated because it always lands on someone who actually did have an actual warrant. Who's to say that the manipulation could not have included landing on someone that they knew had a warrant and that they likely knew where that person was. So that success rate is not a reliable indication that the sheriff was acting in his scope. But I would just submit that just the wheel itself is not something within the scope, just due to the particular facts. If the sheriff was actually running the wheel and the wheel was called Wheel of Warrants, and the warrant and the people on the wheel actually did have warrants at the time that it was put out, I think you'd have a good argument. But the show is called Wheel of Fugitive, and it features people that don't even have warrants. I would submit that that indicates that this is really a promotional show for the sheriff to try to get likes and followers on social media, not to exercise his duties of serving a warrant. And because the sheriff would not be immune from suit from serving someone with a non-existent warrant, he cannot be immune from saying that someone has a warrant when they don't. Okay, so the sheriff's argument in this regard kind of lends to an unreasonable conclusion. Let's say that the sheriff wanted to put somebody on the wheel and say that they were a rapist, but in fact he knew that they were not a rapist. The sheriff's argument said, well, he's immune, doesn't matter. What if the sheriff wanted to target a political opponent? And they're saying, well, too bad, so sad. The sheriff is allowed to do the wheel, and the wheel is to serve warrants, and whoops, we messed up, but too bad, we're immune. And I would argue that it does not go that far. I know that the scope of some of the officials' duties are to be liberally interpreted. I know that that is the Florida case law, but the Test of the Jupiter case, the one that I emailed that the court is going to look at, which for the record, the citation is 358 Southern 3rd, 780. It's a 4th DCA case from 2023, talks about a public official. The scope is all matters that a public official is authorized to perform. Yes, the sheriff is authorized to serve warrants. No, the sheriff is not authorized to serve non-existent warrants. No, the sheriff is not authorized to call someone a fugitive when in fact that person was cooperative, as Mr. Gay was. He was out of custody. He was reporting to probation. He gave his information to probation. They asked him to come in and sign a piece of paper. He said that I don't have a ride. Gave his address, showed up, and they arrested him on a BOP. I think he was going to have a BOP warrant for some time because he'd been on probation, got arrested for getting involved in a dispute between his parents, etc. Got out on bond, kept asking, was cooperative, here's my information. So no, the 11th Circuit, it's interesting to know the 11th Circuit has a little bit better definition about what is in scope. And its definition is the official performing a legitimate job-related function? I would argue that not, because there's non-existent warrant here, and he's labeling him a fugitive when he's not. And is the official doing it through means which are within his grant of power to utilize? And I would argue having a Wheel of Fugitive show that has people on it who do not have warrants is not within his grant of power. Florida law does say when actions serve no official purpose, it cannot be said to be within the scope of officials' duties. And that's the Albritton versus Gandy case that I cited, which for the record is spelled ALBRITTON versus Gandy.
And you said that when you sent over to me as well, correct?
I believe so. I believe so. I will double check.
If you didn't judge, I did.
And for the record, that's 531 Southern 2nd, 381. It's a first DCA case from 1988. So again, since the sheriff is not authorized to serve non-existent warrants, it can't be within the scope. And in any event, the sheriff is not authorized to call cooperative citizens fugitives, a label that carries a very heavy burden. So if you look at the amended complaint does not facially establish whether or not the sheriff was acting within the scope. I know that I cite the statute in some of the counts that has within the scope language, but at no time in the actual allegations do I allege that the sheriff is acting within the scope. The statute is cited for the sake of the immunity argument that was going to be coming. What the sheriff is asking you to do is find that as a matter of law, anything that he does on a social media show basically is immune if he asserts that it's serving some sort of purpose. But in reality, they haven't raised that defense yet because they haven't answered. And I believe that the amended complaint actually undercuts the purpose that they put forward, that the sheriff, in order to try to get this dismissed, AKA the serving of warrants, because it attaches the 12 pages of the people who were featured on the wheel, mentions that the wheel was obviously manipulated. So for that reason, I think that it should be denied. If the court finds that it should be denied because the amended complaint does not faithfully establish that the sheriff was acting within the scope, because in reality, this is something outside the norm. But if the court finds that the amended complaint does facially establish that Sheriff Ivey was acting within the scope, then I think you then get to the immunity aspect of it. And I am very well aware of the cases that talk about absolute immunity for officials in defamation cases. And those cases started in 1966 with the McNair case that the defense cited to you. And then there's another case that's relied upon commonly that I believe the defense provided. It's the Hauser v. I don't know how to pronounce it, but it's HAUSCR versus UR.
Number 15 on their list. Yeah,
probably. Yeah, it's that case. And obviously these two cases predate the passage of the statute. The statute was passed in 1972. In those cases, McNair's from 1966, and the Hauser case is from 1970. And this is important because these are the two cases that all the other cases subsequent to the statute tend to rely on. And very few cases, except for the few that Mr. Koiza did bring up, address or try to reconcile the passage of the statute. It's important to note that the McNair case found that officials were absolutely immune, but also on page 430 said, quote, if areas of absolute immunity and qualified immunity are to be carved out of the executive branches of government, it should be more appropriately and historically more properly done by the legislative branch, end quote. And then in footnote 6, the McNair court said, quote, the legislature, for example, could extend absolute immunity to certain high state, county, or municipal officials or do away with immunity altogether. This court, in the exercise of its judicial power, decides cases. It does not reach into the future and decide controversies not yet arisen. Historically, the legislator draws a fine line between lawful and unlawful conduct and between acts which are the basis for actions and for damages. And so my assertion is that the passage in 1972 of the statute 768.28 does exactly that. The problem is with the two cases that were cited by the defense, by the sheriff, those cases merely cite back to McNair, the pre-statute cases, and they cite the policy that those cases cited at the time. And then they say, well, the legislator didn't mean to exempt. If they did, they would have said anything. And I think it's important to look at the plain meaning of the statute. And every other time that we do interpretation, that's what we do. And the statute does not exempt defamation from the waiver of immunity. In other words, it doesn't say that immunity is waived and all other torts are allowed except for defamation, for which an official remains absolutely immune. They could have said that. Rather, the statute waives immunity for all torts. Yet again, we still have these cases that tend to rely on the pre-statute McNair, which McNair itself said could be changed in the future, and I would argue it was. The only Supreme Court case that I could find that was a post-statute, because the cases that the defense has cited are DCA cases out of the third and fourth. The only post-statute case that I could find by the Supreme Court, and I don't know if I sent this one or not, I'll have to look, was Miami versus Wardlow, WARDLOW, in full disclosure and candor to the court. And that citation is 403 Southern 2nd, Florida, 1981. And it did say that an official was absolutely immune from defamation, but it relied again on McNair and didn't discuss the statute at all, or the fact that McNair said this could be addressed by the legislature, and in fact that it had. So my assertion and argument, and I'm aware that there's case law against this, but I would argue that none of the cases really address this, is that the legislator did speak, and McNair no longer applies, and there's no longer absolute immunity. I know there's this argument about sovereign immunity versus absolute immunity. Functionally, I think that they are the same. And again, if the legislator wanted to, again, exempt, they could have done that, but they didn't. They said all torts. And I think the case that I sent you last night, let me jump here. The Testa case did get into that, but let me get to that when I get to that. The defense's main...
Folks, wait, before you go there, Attorney Travis, I so don't want to interrupt you when you're doing your argument, but if you can pause for just a second. I have to take just a quick recess. I am so sorry, but I do have to just go off the record for just a couple minutes and take care of something, then I will be right back. I promise. All right. Sorry about that, folks. Give me 1 sec. Counsel. Sorry about that. And we can go back on the record. I hate to interrupt you. Sorry about that, Attorney Thomas.
All right. Can everybody hear me? Okay. So I kind of left off talking about the distinction with McNair being prior to the statute being passed. A lot of the post-statute cases relying on McNair and kind of ignoring the fact that McNair itself said that the legislator could address this, and in fact that they have. The main case that the defense relies on is the Crowder versus Batty case. He gave you the citation earlier, and I know that that was one that was sent to the court. And in that particular case, the plaintiff was featured on the Brinch Roundup for having a warrant for child support. And the sheriff said he owed $1 million+ in child support. And if you look at the facts of that case, and in fact, I pulled the complaint in that case, there was no allegation that he didn't have a warrant. In fact, he did have a warrant. It was just that he didn't owe that much money.
The dollar.
Yeah, I didn't know that dollar amount. And so he did owe. And so I think it's factually distinguishable here because, I mean, at least at the time, you know, Mr. Gay had a warrant. At most, he had a warrant for like, you know, probably a day or something because he was, you know, turned himself into custody. But it was, in any event, it was served by the time he was featured on this social media show. And versus the plaintiff in that case did actually have a warrant. And so there was a purpose in serving a warrant. Here, there was no purpose in serving a warrant. It's also distinguishable because that was a one-time kind of publication. And here we have a repeated pattern by a sheriff who regularly included Mr. Gay, who was in his own jail, and numerous other people. And so I think in that respect, as to individual liability and potentially an abuse of immunity argument, it's factually distinguishable. And I'll address that here in a minute. It's also distinguishable statute cases to mainly cite the policy. I did that is actually on point and did not legally. Again, the case that I sent to court last night was the test of the Jupiter Island. And for the record, that's 358 Southern 3rd 780 4th DCA 2023. And in all candor to the court, that has some bad holdings for the plaintiff and it has some good holdings for the plaintiff. But I thought it was important for the court to see. And the reason I thought it was important for the court to see is because it did discuss the statute. It still found that there is official absolute immunity. Again, it relied on the pre-statute case law, McNair, et cetera, which I would argue is not what it should have done. That it ignored the statute and relied on the old inapplicable case law. It did, however, find that a plaintiff or a defendant is not immune under excuse me, 768.289A if the complaint alleges enough for individual liability.
Do you need a minute to please?
Just from talking too much is what it is. So if you look at the statute, which the court indicated that it already has, section 1 talks about the waiver of immunity for all torts while acting in the scope. And typically that is official capacity liability is what we refer to. And then if you look at subsection 9A, it says, and I'm going to paraphrase, leaving out irrelevant words, that an officer may be held personally liable in tort for action in the scope of his employment. Excuse me. Maybe I skipped over too much. An officer, employee, or agent of the state or of any of its subdivisions may not be held personally liable in tort for any act, event, omission, or action within the scope of his employment or function unless such officer, employee, agent acted in bad faith or with malicious purpose or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. And so the tested court said, okay, yes, generally official immunity, still absolutely immune. They relied on the old case law, but it found that that particular subsection did allow for individual liability if those things were alleged and obviously ultimately proven. And it makes sense if you think about it. Well, before I leave that case, further down in the decision, the court also found that the failure to specifically cite Section 9A was not, did not make the complaint insufficient, and that given all reasonable inferences of the facts of the complaint, the allegations could demonstrate that the official acted in bad faith with malicious purpose, and therefore did not dismiss that complaint. So that finding under 9A, I think makes sense in the broader scope, because what the sheriff's position is he can abuse his immunity, he can purposely lie, and he cannot be held accountable because he's absolutely immune for defamation. But 9A kind of says, not so fast, not so fast. If you act in this manner under the statute, bad faith, malicious purpose, a manner exhibiting wanton or willful disregard, you have lost your immunity. And essentially, if you knowingly, subjectively abuse your immunity, you're going to lose your individual immunity. And I think that that interpretation makes sense, even though I disagree with the first part about the absolute immunity. That otherwise, a blanket absolute immunity means that a citizen can never get any justice when an official recklessly, knowingly, intentionally abuses their immunity. In other words, a sheriff or any other official should not be allowed to say whatever they want and then go, whoops, I'm absolutely immune. And no, they're not. And I think the statute says that. Other states have recognized kind of an abuse of immunity law. And I did provide in the courts the Trinacosta versus Beck case. For the record, that's 703 Southern 2nd, 552. It is a case out of the Louisiana Supreme Court from 2007. So, but it does rely on the restatement of torts, which Florida courts rely on a regular basis. And the restatement of torts talks about that an official loses his immunity when it's abused, and that abuse of immunity occurs when someone knows a matter to be false or acts in a reckless disregard of the truth or falsity. Reckless disregard occurs when there is a high degree of awareness of probable falsity or serious doubt as to the truth of a statement. Abuse occurs when the defamatory matter is published for some purpose other than for which the particular privilege is given. And abuse occurs when the defamatory matter is not reasonably believed to be necessary to accomplish the purpose for which it is privileged. And I would assert that all of those arguments apply here and would underline a policy that finds that there is not absolute immunity for an official who repeatedly acts in this manner and makes these statements. He subjects himself to individual liability under subsection 9A. I also cited in my brief that Maine indicates that whether or not there's abuse of immunity is a question of fact. And I would argue that whether or not a sheriff has acted in a manner that is prohibited under 9A is also a question of fact. And the court's only inquiry at this point is whether or not the four corners of a complaint make the allegations sufficient allegations. And Mr. Poisa indicated that the complaint does not, or if it does, it just makes conclusory allegations. And I would point the court to paragraph 100 of the complaint as an example. This is a paragraph that's repeated in the other similar counts. First of all, this complaint obviously incorporates all the facts, but paragraph 100 is titled Bad Faith, Malicious Purpose, and/or Wanton and Willful Disregard of Human Rights, Safety, or Property. Ivey acted in bad faith because, again, Mr. Gay's status as an inmate at the Brevard County Jail and his compliance with probation through the Florida Department of Corrections could have easily been known by Ivey. Further, Ivey's use of Mr. Gay's name and image, despite this known or readily known information, coupled with Ivey's repeated use of Mr. Gay and other individuals who were likewise in jail and who were not fugitives, and the fact that the wheel always landed on someone with an active warrant, never on someone already in jail, suggests that Ivey knew who was and who wasn't in custody, and he intentionally included non-fugitives, and in any event, acted with malicious purpose and/or in wanton and willful disregard of human rights and the safety of Mr. Gay and other persons featured on the wheel. That is not a conclusory allegation. There's facts in the amended complaint that support individual liability, and would support, I think, an argument that immunity has been abused here to the extent that 9A would apply. So the early courts, McNair and Hauser, found absolute immunity based on this policy. And the policy was generally, out of Hauser's, quote, the public interest requires that statements made by officials of all branches of the government in connection with their official duties are absolutely privileged. And that was in 1970. That policy is not furthered when you allow a sheriff to feature someone and call them a fugitive when in fact they never have been a fugitive and they are in custody and have no valid warrant. The law says not only should officers fearlessly execute their duties, but they should faithfully exercise their duties. And again, stamping someone with as a fugitive does not further that. I do not believe that allowing a sheriff to be subject to immunity under the statute, either through subsection 1 or individually under subsection 9A, undermines the policy behind generally allowing officials to speak freely and do their jobs. Most of the cases that talk about deal with officials who have made 1 or 2 statements, not repeated statements, and here we have a pattern of conduct. I think it would be objectively reasonable for any other official to know that this conduct or this language is defamatory and false in this particular case, and that he would be abusing his immunity and subjecting to citizens to danger and ridicule, even if that person was cooperative. I would also note that the old cases, it's important to note that those cases from the 60s and 70s were well before social media, and there has to be some sort of balance here. It is now ever so simple for a sheriff or any other official to make to do self-promotion and try to get clicks, likes, and followers, and then go, whoops, I might have misspoke. I'm absolutely immune. To be clear, this is not a one-off. This is not a one-off mistake. This is a repeated pattern. And so it is disingenuous, I think, to try to use the policy behind absolute immunity to try to justify the conduct in this case. If the court grants absolute immunity in this case, it will basically give a license to sheriffs and or other bad actors to use social media for all sorts of claims against citizens, as I indicated earlier. No matter how false they are, there has to be some degree of accountability or balance between the fact that we want our officials to do their job and not be afraid of suit, but if they step over that line and they abuse that immunity, then they're subject to suit. So if the court doesn't think that does think that there is some degree of absolute immunity, I would assert that 9A allows for waiver of immunity, and that conduct is alleged in the amended complaint. So addressing the amended complaint specifically, counts 1 through 4, defamation in official capacity. Again, I said pursuant to, maybe not artful, but I don't think fatal. There's no allegation in the those counts themselves that Ivey was acting within his scope. I think the defense argues, because it says Sheriff Wayne Ivey at the top or Sheriff's Department, that therefore it's within the scope. Well, that would allow the sheriff to basically put that stamp on anything and get away with a lot. And I think that's disingenuous. The only time that the within the scope is mentioned is to cite the statute. And in count 7 through 10 is the individual capacity. That was the paragraph 100 language that I cited is included in those. Again, no specific allegation one way or the other within the scope. And then counts 13 through 16 is the defamation, official and individual, citing as to common law. So I think the court's options are, if the court finds the amended complaint does not facially establish whether Sheriff Ivey was acting inside or outside the scope, then the motion to dismiss should be denied in its entirety. And the sheriff needs to raise his defenses, and we'll go from there. If the court thinks that the amended complaint facially establishes that he was acting within his scope, and the court is of the opinion that absolute immunity entirely trumps the statute, then I think you grant the motion to dismiss. If the court finds that the amended complaint facially establishes that is within the scope and absolute immunity is partially trumped by the statute, specifically 9A, like Testa found, then you would dismiss some of the counts, but not the others. I think you would dismiss 1 through 4 and 13 through 16, but not 7 through 10, which are the individual liability counts. Again, it's really easy to slip into motion for summary judgment argument. And again, I would ask the court to focus on the 4 corners of the complaint and whether or not they conclusively establish that the sheriff was acting within the scope of his duties. I would argue that it does not. The court is obligated to give deference to facts and all reasonable inferences. And the amended complaint establishes that the sheriff's use of David Gay's name and calling him as a fugitive and using his booking photo were not for a valid reason. And the wheel itself is not a real valid exercise of power just because of the things I mentioned earlier. I would argue that the conduct is more than merely gross negligence because it is a pattern and it's been repeated, and that is proven by the 12 pages of other individuals that are attached to the complaint. And that is an issue that the court cannot find, I think, at this moment as a matter of law. I would argue that the intentional infliction of emotional distress and the reckless infliction of emotional distress are certainly outrageous. I'm aware of the independent tort doctrine, and the court can rule accordingly on that. Again, if the court finds that some are duplicative, you can strike some of those, but I don't think that the complaint in and of itself should be dismissed entirely, or certainly not dismissed without prejudice, because I do think that there is a cause of action here. And specifically, I think 9A is applicable. Or ultimately, if the court finds that this is not within the scope, then there's no immunity whatsoever. But again, I think that that's something to be decided on another day. So for those reasons, I'm asking the court to deny the motion to dismiss.
Thank you. Thank you. And attorney, and I've already forgotten how to pronounce your name. What is it?
Kazera, Your Honor.
Kazera. Okay. And Attorney Kazera, any response briefly?
Yes, Judge. Thank you. So, Judge, just a quick clarification on the facts. I mentioned this at the outset. Just the sheriff disagrees with plaintiff's assertions factually that Mr. Gay was never a fugitive. We disagree with his assertion that he was not wanted on an outstanding warrant when he was initially featured on the wheel. We contest those facts. I understand that we're in a motion to dismiss and that we're limited to the 4 corners of the amended complaint at this point. But I want to note it to the extent that it forms the entire basis of Mr. Gay's argument. It's the sheriff's contention that at all times he was acting with proper purpose in this case. One of the initial arguments that was raised by Ms. Travis is that while serving a warrant might be within the scope and authority of a sheriff, apprehending a fugitive is not, or calling someone a fugitive is not. because this is hair splitting it's a distinction without a difference. Sheriffs are allowed to serve warrants. Sheriffs are allowed to apprehend fugitives. Those are both within the scope of the sheriff's authorities. Ms. Travis then argues that the analysis that the court should undertake with regards to the absolute defamation immunity is first determine whether on the face of the amended complaint he was acting within the scope of his official duties, and then second, ask whether, if he was, he qualifies for immunity. And with respect, that's not the test. The test is one question long, and that is, was he acting within the scope of his official duties? If he was, that's the end of the analysis. If he was acting within the scope of his official duties when he made the statements, he is entitled to absolute immunity. And absolute means absolute in this case. It does not mean qualified. It does not mean under some circumstances. It means absolute. Ms. Travis repeatedly over the course of that argument conflated the two immunities that are at issue here. One is absolute immunity for defamation, and the other is sovereignty. When she talks about 768.28's waiver of immunity, she's talking about the waiver of sovereign immunity. It does nothing to absolute immunity. It doesn't address it in any way. Her argument, Judge, that the amended complaint does not specifically lay out that these actions were taken in the course and scope of his official duties, I think fails for two reasons. I discussed them at length before, but I'll just briefly note. First, more than half of them are official capacity complaints. Those have to be in your official capacity. That's what it means. Second, the allegation is not that he, got into an argument with somebody at Walmart and said mean things about him. The argument, the allegations in the amended complaint are that he made public statements seeking to apprehend known fugitives. Those are within the scope of the authority of a sheriff. Plaintiff argues that because this was done on a promotional social media show, that the analysis should change. Plaintiff cites no case law for that, for the idea that the law has changed with the rise of Facebook. And obviously many of the cases that I cited were from the last 10 years or so that discuss the fact that this immunity still exists. I find no authority anywhere in the law for the idea that the way that you distribute a public statement as a public official has any bearing on your absolute immunity from defamation based on that. She indicates that this was not really an attempt to serve warrants. Again, Judge, I would invite the court's attention to the pages that were attached to the amended complaint, which show that the person on the wheel was successfully apprehended 83% of the time after they were featured on the wheel. If this is not an attempt to apprehend fugitives, it sure is doing a good job of apprehending fugitives. She argues that calling someone a fugitive who is cooperative is not within the scope of his duties. This is exactly the same argument that was raised in Crowder v. Barbati, where Mr. Barbati was labeled a deadbeat and a Grinch. Calling someone a deadbeat or a Grinch was found to be within the outer perimeter of the official's duties. It is the same as calling someone a fugitive here. Apprehending fugitives is part of what a sheriff does. There's two brief things that I want to mention. One is that she indicates that the test in the Jupiter case that she sent over, I do highly recommend that the court read the Jupiter case. I think it's very helpful to us, and I think it addresses a lot of these issues. In the Jupiter case, the defendant raised both of these arguments. An argument that, hey, you can't sue me for defamation because public officials have absolute defamation immunity. And separately, that there is an argument of official immunity under 768.28. And the court took pains to separate those two and to say whether there's a waiver of 768.28(9)(a) official immunity has no bearing on whether the public official is entitled to absolute immunity. So I highly recommend reviewing it in detail. But I will note that she says that the test of the Jupiter case is whether the act was a matter that he was authorized to perform, and that he's not authorized to serve an invalid warrant or falsely call someone a fugitive. This is the learned hand argument again, that a public official never acts within the scope of his duties when they are alleged to have acted falsely. Over and over again, the case law says that that's not the test. The test is whether, if the statements were true and were made with a valid purpose, whether they were the sort of act that the public official would be authorized to do. The last thing that I'll mention, Judge, is she brings up Albritton v. Gandy. That's 531 Southern 2nd 381. Says that when a statement serves no official purpose, it has no immunity. I cited Albritton v. Gandy in my motion as well because I think it's a great case for us. It's a first TCA case that held that a county commissioner's attempts to pressure another officer into firing one of his political rivals was not privileged because the county commissioner had no authority to hire or fire anyone. It was simply not something that he was authorized to do, even if it was done with the right motivations. It wasn't something that he was authorized to do in the scope of his jobs as a county commissioner. It can't be something that is completely foreign to your job duties. But in this case, the allegation is that it was an attempt to apprehend fugitives. That's what sheriffs do. Judge, I believe that those are all the issues that were brought up that I felt really needed to be addressed in rebuttal. If the court has any questions, I'm standing by to answer them. I guess just the last thing that I'll leave you with, Judge, is Ms. Travis, I think was very candid with the court, and I appreciate that, about the fact that a number of these cases that were cited by the defense have holdings that are directly contrary to the arguments that she's making. I'm talking about Quintero v. Diaz, I'm talking about Weeks v. Town of Palm Beach, I'm talking about Miami v. Wardlow. All of these cases hold that 768.28 did not abrogate the official immunity, or excuse me, the absolute immunity for statements made by public officials. I do appreciate Ms. Travis acknowledging that there are contrary holdings, and I will just note that the only cases that she has to support her argument are from Louisiana and from Maine, and they have different common laws that are not even remotely persuasive as to the scope of Florida common law immunities. I think the case law in Florida is very clear. So I appreciate the court's time and patience throughout the course of this hearing.
And Attorney Travis, and I just, well, it goes to both counsel, but I did want to make or get one point of clarification because I thought at the very end towards your argument, and I think you had talked about it earlier, Attorney Travis, you had stated that he had, in your facts that you alleged, that he had turned himself in on the warrant. And I was looking, I thought I remembered it, so I looked it back up, paragraph 27. They actually did execute the warrant on him. They went and got him. And I understand the prior paragraph, he said he called his probation officer. They had something for him to sign. He couldn't get there. So, he was somewhere else. So he gave the address where he was, being cooperative, but that they showed up and actually did take him into custody on January 25th, 2021. And then I do understand the rest of your argument being then the next day he did show up on, I think it was the next day, shortly thereafter showed up on the wheel. I think it was the next day. I just want to make sure that I didn't that.
Misrepresent. I probably said turn myself in, like a lot of my clients say, well, I turned myself in because I told them where I was. But yes, you have to understand. Okay. That's correct.
Okay. Since I have a felony assignment, for me, those are two very different things. When folks turn themselves in at the jail versus when law enforcement has to go to somebody's house, business, somewhere where there's public and it's a little different situation. So but the facts that you had alleged were not that he turned himself in, they were that he cooperated in telling them where he was so they could apprehend him, correct?
He did not have a vehicle, yes. He cooperated until he gave his address.
Okay, all right. And that's perfectly fine. I want to make sure I was clear on the distinction, because when I heard you say that, I thought, well, maybe I misread or misinterpreted something. Okay. Alrighty, that was the only question I had. I just needed that clarification. And I will I'm going to actually, now that I've listened to the arguments, obviously I'm going to look at the case law that I saw as we're sitting here on Zoom. I could see some more case law. Attorney Travis, I think, I don't know who it was. It came from my judicial assistant. I saw some case law coming through on this. I'm going to assume that was from Attorney Travis's office because I know she said she would. But any of the case law that y'all got over to me, I will make sure I read that. And then I also, though, some of these cases based on the argument, I want to go back and read again now that I've listened to the arguments. And then I will try to get an order out to y'all as quickly as I can.
Thank you very much, Judge. I don't know. I don't know the court's sort of procedures on this, but just do you have any idea as to a timeline on receiving an order? How long do these typically take to come out?
Well, civil's lower on my schedule than felony. I do have 6 jury trials set before me on Monday. The last I looked, I think this morning it went down to maybe 4. So I do know that I'm going to be in jury trial next week. I'm going to do my best to therefore get it out this week. I usually don't sit on, every judge is different. I usually try not to sit on stuff for too long. The problem is there is a lot of case law in here that I do need to review. So if I can't get it done, because I have some stuff going on in my office that I need to work on. So I'll try to get it out by the end of this week. But if it is not, there may be a delay in that because I'm going to be in trial next week. So if it doesn't come out by the end of this week, I doubt it will come out. Don't expect it next week because I will be in 2 jury trials as it stands now next week. Okay. Alrighty. Thank you, folks. It was nice meeting y'all. Take care.
Thank you very much, Judge. Take care.